orders, they have a whole schedule, the second schedule that deals with the procedure for impeachment of a president or deputy president. And they elaborate what will happen if the Senate is dealing with the impeachment trial in plenary, which is what is happening. And they indicate what happens with the trial, the opening statements, the cross-examination of witnesses, the closing submissions, the final comments by the senators, which is what we've been seeing, and then now they prepare to vote. And the standing orders are very express that each count shall be voted on separately, which is what we've heard the Speaker of the Senate actually reading to his members of the House of the Senate. And so they will vote on each of the charges, and if the vote is successful in favor of the impeachment resolution of the National Assembly, the Deputy President stands removed from office immediately. And we can expect any time after that, there will be a Gazette notice confirming his removed from office. And the President, now under the Constitution, immediately, in any case within 14 days, can nominate a new person to come in as Deputy President. And this person to be nominated by the President can be nominated tonight or tomorrow morning. We are aware that the National Assembly will have a special sitting tomorrow. The Constitution gives them 60 days to consider any new person nominated for Deputy President, but they can even choose to vote tomorrow, the representatives of the people. So it's a very accelerated process, and what I would summarize by saying is that both the legal teams of the Deputy President and those who are supporting the impeachment are in a race against time to establish a new status quo so that when the court, the three-judge bench, eventually comes to determine these many legal and constitutional questions about the process, they will be saying, preserve the current status quo. If the status quo is that there's a new person in office, as happened with the impeachment of Governor Mike Sonko of Nairobi a few years back, and Kananu was already sworn in, that status quo is likely to prevail. That's why there's a race against time. It's almost an indecent haste to get everything done. And that can explain even the decisions you've been seeing on procedural matters today, including on the question of whether there will be an adjournment until Tuesday.
Interesting. Sam?
Right. The events of the day, but I'm just wondering, Wakili Abdikadir, because now...
Sorry, Sam, just hold on one second. Let's listen to the Speaker.
That the National Assembly on the 8th of October 2024 resolved, with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145 in evidence of the proceedings of the National Assembly. Further, whereas pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathe Gachagua, AGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, The Senate also had His Excellency Rigathe Gachagua, EGH, Deputy President of the Republic of Kenya, on the grounds of his proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, therefore, pursuant to Article 145, as read with Article 150, 1B and 2 of the Constitution, and Standing Order 78 and 79 of the Senate Standing Orders, the Senate resolves to remove from office by impeachment His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on the following grounds. 1. Gross violation of Articles 10, 2A, B, and C, 27(4), 73(1)A and 2B, 75(1)C, and 129(2) of the Constitution, and Article 147(1) as read together with Article 131(2)C and D of the Constitution. 2. Gross violation of Article 147(1) and 152(1) of the Constitution by undermining the President and the Cabinet and the effective discharge of the national government's executive mandates. Number 3. Gross violation of Article 6(2), 10(2)A, 174, 186(1), 189(1), and the fourth schedule to the Constitution by undermining devolution. Number 4. Gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Number 5. Gross violation of Articles 3(1) and 148(5)A of the Constitution on the fidelity to the oath of office and allegiance. Number 6, serious reason to believe that His Excellency the Deputy President has committed crimes under Section 13(1)A and 62 of the National Cohesion and Integration Act. Number 7, serious reason to believe that His Excellency the Deputy President has committed gross economic crimes under Sections 45(1), 46, 47(a)(3), and 48(1) of the Anti-Corruption and Economic Crimes Act, and Sections 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. Number 8, serious reasons to believe that His Excellency the Deputy President has committed crimes by continuously misleading members of the public through false, malicious, defensive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. Number 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency, the Deputy President has publicly attacked and undermined the work of the National Security Intelligence Service and its officers. Number 10, gross misconduct by openly or publicly insubordinating the President, who is the head of state and government. And number 11, gross misconduct by persistently bullying state and public officers. As I've already indicated, honorable senators, voting shall be done electronically. So at this juncture, I will ask honorable senators to pull your cards out of the delegate unit. Sergeant at Arms, kindly go around and pick all the unattended delegate cards. Sergeant at Arms, if you're done collecting the unattended cards, we're good. Now, honorable senators, you may log in back. As indicated earlier, we'll be casting our votes 11 times. So the vote you're going to cast at the moment is for charge allegation number 1, which is gross violation of Articles 10(2)A, B, and C, 27(4). I had already read it out. So from this moment, it's beamed on the screens. So, honorable senators, once you've logged in, you may now proceed to vote.
Right, so what you're seeing on your screens right now is the electronic voting process that is ongoing. Remember, all the senators present in the House will be voting electronically on each count. Remember, the deputy president is facing 11 counts of impeachment. This is currently charge number one. Sam, numbers.
It's clear to say that the deputy president has been impeached.
Yeah, one count.
53 have voted in support of that ground. Everyone has voted because the total is 66. It appears in the Senate.
Yeah.
You just needed 45, which is 2/3. 53 is 80%.
Good. On that, Abdikadir, I just want us to understand, 11 counts, what is the threshold? How many counts does he need to be found guilty of for him to stand impeached?
One.
Just that?
Any single one. Yeah.
Any single one?
Because the motion could have just been one motion, one item.
Yeah.
There was no requirement for 2 items or 2 charges or 3 charges or 4, just one.
So what happens next now?
So it's a question, I think.
Wait, sorry, before you even go to what next, so will they vote on the other 10?
Yes, indeed. Yes, indeed.
They will have to vote on...
They'll have to vote on each one until the end of the order paper. And the requirement is there were 11, they have to go down the list.
Okay, but as it stands now?
That first one is done, and therefore, the totality is, of course, they'll have to announce it, but the totality is from where we stand, he's impeached.
So what happens next?
He's legally out of office as we speak now, constitutional.
Okay, all right. So this is...
I think the remaining 10 charges.
It's almost an anticlimax of sorts.
It ended so fast.
Just in the sense because, you wanted to see how the voting takes place over... all the 11 counts.
I think the problem is the electronics. Before, you remember, it used to be a physical vote. Right now, the electronics makes it so fast. But to follow up on an item that Charles had said earlier, which I think we were discussing off camera. What happens next? What happens next is a political process. How fast that political process goes is how fast those in government want it to go. And those in government can be very efficient when they want to be.
Yeah,
so
and
it's highly possible that we'll have a gazette notice out. It's very highly possible that we'll have a nominee sent to the National Assembly by very early tomorrow morning. And it's highly possible, as Charles has said, under Article 149, that they will be done with that by tomorrow. Now, the question then that comes is, for cabinet members, for PSS, for high-level appointments, usually you have a vetting process with public participation, with a committee set up. Are they going to go through that process, yes or no? My view is that if they wish to go that way, it's possible that they do. But this particular section doesn't require that. And Article 149, the language is to vote for the nominee, vote up or down. Under 152, which is where the cabinet and other high officials come through, the language is approve. Approve presupposes a process of some form of process of vote. Is just like what happened right now. It's a vote. It's not consider and vote. It's just vote. And the perception is this is a very specialized process. Impeachment is really a closed, specialized process. Notice, for example, there are criminal offenses being alleged. Those criminal offenses, under normal circumstances, one needs to go to jail if they are convicted, one needs to be fined if they are convicted, and if that process ends, one cannot be charged again for the same offense.
Okay.
All those things are not the same case here.
I want you to hold that thought for
Look at
just a
that,
moment,
yeah.
because I would like us to just update our viewers on this news that is just breaking. If you have just joined our live broadcast, the breaking news that is in is that Deputy President Rigathe Gachagua tonight stands impeached, making history as the first sitting deputy president to be impeached by both houses of parliament. He was facing 11 counts, and they have voted on one. Well, they're, I think, voting on the second or the third one by now. But the threshold that is required is that he only needs to be found guilty of one count. And that was the very first count, charge 1, gross violation of the Constitution. And 53 senators voted on the first count that he has been charged with, thereby impeaching the deputy president of the Republic of Kenya. What a dramatic day that has been, even as he tonight spends the night in hospital, having suffered chest pains earlier this afternoon. The process proceeding in the Senate, that is the second or upper part of the House. That's how they like to call it, as part of a bicameral process. And so, Jamila, on this day, and this has happened, you know, shortly before 11 o'clock.
And I find it interesting that Wakili has just said that as it is, it's only one count is enough to get him out. They just voted on the second ground. And it was really interesting that only 28 were for and 39 were not. So if this had been the first ground that they had voted on, he would still be the sitting deputy president. But it's interesting how the senators are voting on the second one. It was about also gross violation of the Constitution. But for this one, they voted with him. But as you said, Yvonne, and as Wakili said, that this is it. It's over. And you talk about
Jamila,
a political... Yes.
Just to cut it short, because it's important to just explain that the first ground that the Senate has impeached or has voted to remove the deputy president from office by impeachment is one that is touching on the sentiments that he, the utterances that he made about serikali ni kama kampuni ya shares.
Yes.
So that is which that they're supporting with 53 votes. The next one, the second one that has been defeated is the ground on insubordination of the president, undermining the president, where you have some 28 senators voting to agree with the ground, but another 39 disagreeing with it. This is the third one, which is on the gross violation and the fourth schedule of the Constitution. This is on devolution, the question of Nairobi County and Governor Sakaja. Already you can see that a majority, which is 45, are voting not to substantiate the ground, meaning he's not being impeached on this ground. So far, it's just the first ground.
Yeah, so there we go. It would then be, Linus, the infamous statements around shareholding and likening the Republic of Kenya to a company that would prove to be...
It was certainly the most likely charge out of all the 11 that would directly have a bearing on the future of the political career of Deputy President Rigathi Gachagua. And it's one that members of parliament, starting with the National Assembly, found it quite very easy to articulate. And even in the Senate, this is the low-hanging fruit, if I can call it that way, because this is one of the areas that the deputy president, now former deputy president, going by the result of the first charge, because as it goes, and the constitutional experts are in the room, Article 145, sub-article 7, actually, presumes immediately that the deputy president ceases to hold office as soon as he is impeached, and that's the result of this vote. And the issue of the utterances around shareholding, you realize that that's where a lot of the strength of the motion mover was coming from, playing the clips that were collected, a majority of them from the media circles. And I think there is something else there.
Yeah, the independence of judges, that's
another
ground 4.
Yes, that is ground 4.
Yeah.
The independence of judges.
Which was about independence of the judges. Justice Esther Maina. Again, 51 senators have voted to impeach, meaning this is a ground that has been substantiated in the eyes and in the minds of the senators. Yeah. So that's the second ground. of impeachment.
And that'll be quite an area of debate because if you look at the clip that was used in illustrating the attacks on the judge, if you play further down, just after where the Senate stopped reviewing the footage, you'll realize that more leaders actually were not very kind to the judiciary. So there is a bit of convenience also that will go into this political voting. On the clip that was used, the former deputy president was not the only speaker who expressed himself, especially in terms of attacking the judiciary. But again, this is parting times. I think he's paid the price. There are a few more people in the clip that will not pay the price, but he has paid the ultimate price.
And one of them was saying, a very important person in this country was saying that the time for judges hiding behind the independence of the judiciary to sabotage government programs needed to end. That clip was not played in the Senate.
It wasn't played in full, yes.
Yep.
Ah, yes.
Which count is this?
This is ground five.
And the count
On the oath of office and allegiance.
and let's see where that goes. If it goes,
Yeah, they're voting to impeach on
beyond.
that one.
Just one more is needed. There we go.
Yeah, so it also succeeds.
Yeah.
46 voting in support. Oh, well, now 47 and still counting because the total number of senators is 67. It talks about
Oh,
obeying the Constitution and preserving it. 49 voting to impeach, 16 disagreeing with the ground, and 2 abstaining. Again, the third count has been sustained.
Wakili was talking about how political this process is. We'll not be surprised if we see a Gazette notice out tonight, and then
There you go.
the privileges that the deputy president, the former deputy president, had in terms of security and vehicles and all that. Could that be withdrawn?
It moves very fast, and those come with the office.
Yeah.
And if I was just to read the article that the gentleman mentioned, the Kaikai, it says if at least 2/3 of the members of the Senate vote to uphold any impeachment charge, the president or the deputy president ceases to hold office. It's just that fast.
Okay, Charles.
So the office,
Yeah.
if you cease to hold office, the privileges of the office.
Yeah.
Now there was some discussion about can I hold, some background. The key is if you held office for 2.5 years,
Yes.
even if you are impeached, you still retain. It's assumed that you have been a former deputy president. If it is for less than 2.5 years, that does not sustain. On the other hand, if you serve, now whoever comes in,
Yeah.
if they serve for more than 2.5 years,
They
that's
will get-
considered one term.
So they will get perks at the end of.
They'll first of all get perks at one, and 2, they can only run for a second term. In other words, the 2.5 plus is considered a full term.
All right,
Yes.
just pause for a moment, because this is the 6th ground, and once again, the senators have voted to find him guilty on
Yes.
count
Ground number
ground
6.
number 6.
Serious
Sam?
reason to believe that His Excellency the Deputy President has committed crimes under various sections of the National Cohesion and Integration Act. Some of the illustration of that was also the question of shares.
Yeah, that would seem to
48.
be, yes.
48 out of 67. That is
There, yeah, final
71.6.
count.
Of course, they needed 45.
Yeah.
So how many grounds do you have so far?
Out of
4.
the 6, we have 4
4
Yeah.
so far.
voting against.
Yeah.
Right.
So let's see. Yes. So we
Somebody
apologize for that.
impeached our signal?
No, I think it was a signal that was coming out of Parliament. The screen that is showing the vote tally. And so Abdikadir was saying about the perks, and whoever would take over from office now until the next election would be deemed to have served a full
If
term.
they stay for 2.5 years.
If they
Yeah.
That's an important rider, Jamila.
that sounds
Thank
like
you.
a full term.
That's a very important rider. Charles, even as we see how the vote goes for ground 7, so in practical terms, we've talked about, the perks and everything. What happens to Rigathe Gachagua?
The situation is not completely clear because there have been different outcomes for different governors. There who have faced something similar. Right now, we have a governor who's still in office, despite having been removed by the Senate earlier than Deputy President Rigathe Gachagua through orders, conservatory orders. This is ground number 7. This one has failed. This is the one on corruption, money laundering, and issues of the assets he's been acquiring, that the Deputy President has been acquiring. So this particular ground has failed.
The senators,
So far we have 4 counts that have succeeded and 3 counts have failed. And as we are speaking about what happens next, there are those who are able to preserve status quo. However, the Deputy President has previously tried in the court. In fact, there were so many petitions that were filed, several of them were consolidated.
26.
Yes, exactly. And by the time the 3-judge bench was dealing with the question of conservatory orders, there was already a decision of a single judge on the same matter. And there is a legal term that we call res judicata, something that has already been decided. You cannot now go back to court and try to get a different position unless you go on appeal to the higher court. So the Deputy President's team will try to have a new application to preserve status quo. They'll say the situation has changed, but they'll be facing that challenge of convening a bench, the same 3-judge bench, quickly enough to deal with the matter. So one possibility is that he goes the way of Governor Kawira Mwangaza, or even as happened formerly with the governor of Embu in his first term, Martin Wambora, and manages to pose the outcome of the Senate process of impeachment. The second option is that he fails to do so, and he remains out of office, like what happened to Governor Mike Sonko. And if you are out of office, then it means that your political career suffers a big hit. We'll discuss that. We are now in ground number 8. This one also seems to have failed. This one is about false, malicious, divisive and insightful remarks contrary to the Penal Code and Leadership and Integrity Act. This,
But how do they split this from the first judge?
I don't think
let me
fails.
explain.
Yes.
The first about 4 counts were relating to violation of the Constitution, because the Constitution has 3 basic grounds upon which you can impeach a Deputy President. The next set of grounds, the ones we are looking at now, these counts have to do with suspicion that is committed a crime under local or international law. So this one, the threshold is a bit higher, I think, than the one for violation of the Constitution, even though the courts have said the standard of proof is what in legal terms we say above the civil standard, is more than balance of probabilities, but below the criminal standard, which is beyond reasonable doubt. So you need to prove the evidence to a certain standard that is in the middle between civil cases and criminal cases. So it's possible to find someone has not met the test for one of the grounds and has met for another, even though the grounds seem or the counts seem connected, which is what has happened here, that you engage in action that was contrary to the National Cohesion and Integration Act, but yet on the question of divisive remarks under the Penal Code, you've
to add, it also shows the coloring of judgment. Parliament understands the first charge. It's very clear. It's a very political charge. Parliament is not very comfortable with anti-money laundering or theft. For obvious reasons.
It cuts too close.
It cuts too close. So you need to understand that this is the court.
So glass houses, huh?
Absolutely.
I wanted to, yes.
Just before you carry on, I've noticed something and I'm wondering if it's procedural. Ground number 7, at some point, 14 had voted yes, and 52 had voted no. Then it changed from 14 to 13, and from 52 to 53. So someone appears to have changed their vote.
Can you change
from
the
yes
vote?
to no?
How does it work?
I believe you can. These are parliamentary processes. Within that time of voting, I don't know.
So before the window closes, you can?
Yes, exactly.
Okay, there's a time frame.
If you put the card in the wrong slot, You can put
have
it in the
time to-
correct slot.
Okay. All right. There was something I wanted to ask because, you know, when they were last in court, they had sought leave to perhaps amend their petition for something tomorrow, Charles? Or
I was going to say something about the court process.
Yes, yes.
First
Please
of all,
do, because you've said some interesting things on X.
Yes. So first of all, the procedure under the statute, which is where the governors were being processed, and the procedure under the Constitution, one is senior to the other. Even though it's actual carbon copy, the leeway the courts have is different. This is the Constitution, number one. Number two, the decision in the Wambora case at the Supreme Court has been very good in terms of setting the law. In my opinion, the courts have very little leeway to interfere with or interface with this process. So, for example, we have just had criminal cases, criminal charges. Yeah. What you would expect if somebody was found guilty of a criminal offense, that there would be criminal sanctions. That is not the case. Nobody's going to jail. Yeah. Nobody's going to be fined. They will lose their job. So this process is a specialized, very watertight process, very seriously timelined. And I think the courts involving themselves so deeply in this process was a misdirection. It was actually not constitutional, in my opinion. Because look at it. Wambora started in 2014. And he was impeached by the county assembly and got a stay. By the time it went through the processes to the Court of Appeal in 2017, 4 years later, the Supreme Court said he was rightly impeached and should not have been in office. That surely was not the intention of the Constitution, especially when you'll be dealing with a president, not the deputy president. What would be the situation when you have a president impeached by both houses of parliament in office by virtue of the decision of one judge in the High Court, anywhere in the country, for the next 3 years, for example, while the Senate and the National Assembly have it will be political gridlock and a very, very dangerous situation. That's why impeachment is a very short process. It's really a short, I like the term used by my friend Harvey. It's a constitutional coup, so to speak. Yeah. And you don't take very many years of legalese to go through those things. You need to move, just like when there's an election petition at the president's level, it is very short, it's within 30 days, and the president asked, don't take office until we are done with your case. It's for good reasons.
I think I want to push back a bit, Counsel, on that argument, because for Kenya, I think this constitution has been a bit like moving straight from walking on foot to driving a Ferrari.
Okay. Yes.
And when you look at the impeachment clause, it's so sophisticated. I don't think it's written for our environment. It presumes that we actually impeach because of impeachable reasons. Okay. When you see impeachment and how we use impeachment in this country, and you just want to look at how it's done in the counties, it's used more as a political tool. It's one of the tools that are available for you to fight your opponents. It could be something as simple like, oh, we don't like you. Because
Sorry, Linus, just hold that thought. Ground number 9, they voted to impeach him. 46 votes versus 20. That's ground number 9.
This is the speech, 26th of June, 2024.
When he spoke in Mombasa.
Mombasa about the National Intelligence Service.
Right.
The senators agree that that is an impeachable ground, 46 voting in support, 20 disagreeing, 1 abstaining.
Okay, sorry.
Just to clarify, we are now in the counts that are dealing with gross misconduct. We have the first 5 counts had to do with breach of the Constitution, then the next 3 grounds or counts had to do with violation, belief that you have committed a crime under local international law. That is ground number 6 to 8. Then ground number 9 to 11 are related to gross misconduct. So this was the first of the gross misconduct counts that has been voted in support of the impeachment resolution.
Yeah, that's an important one on gross misconduct. Linus,
Yes,
go back to your point. You were...
Yes, I was just illustrating
Yeah.
on what we would consider misuse of impeachment. And I just want us to look at the illustration that is with us now, which is the impeachment of former Deputy President Rigathe Gachagua. Count one, which was about his pronouncements, shareholding. If the political community actually felt he was wrong, how come nobody ever contradicted him
In public.
in public, especially in the first year of office? We will not forget that Rigathi Gachagua was the warrior of the Kenya Kwanza campaigns, the man who displayed a very low capacity for embarrassment. And he went for his opponents, you know, in a very shameless way. Whether it's former President Uhuru Kenyatta or Raila Odinga, there was no holding back when it came to what Rigathi Gachagua could say. But nobody told him, hey, shareholding is bad language. It's impeachable. But further down the line, relations between him and the boss soured. And there was this, well, I believe, looking around for whatever charges that can be found to impeach him, including talk of money laundering. And I'm beginning to think, did someone regret why the 200 million case was dropped? Because it would have come in handy.
Right.
Yeah.
Sorry, count 10.
There's some
we just
developments.
had ground 10.
Yeah.
We didn't get to 45.
Right, and this is the one about insubordination of the president. Yes, 22, no, 44. They don't. Majority of senators don't believe it's a ground. And that's tallies with what they found under the undermining of the president and the cabinet earlier on in ground 2, where 28 were voting yes.
Yeah.
And what is the other number? 39 were voting no.
Yeah. Okay.
So Linus, I think on the issue you had mentioned, look, if many state officers were put to this test, they would fail. Many in parliament or in the cabinet or elsewhere, many people would fail this test. Number one. Number two, clearly there are political knives at work in the process. So that, I think, and thirdly, the public in Kenya has a very low trust threshold for our politicians. So all that is absolutely correct. Having said that, it is the public that has voted for members of our parliament. They actually are currently members of parliament. So the functions they undertake as members of parliament are constitutional and legitimate functions. And finally, this actually is a political device. So for example, Charles is a very good lawyer. If he was tomorrow, without any process in parliament here, on a normal sunny day, file a case in the High Court to say, I'm going to file a case for impeachment. The High Court. The High Court, most lawyers will tell you, has unlimited jurisdiction. So if Charles was to wake up one morning and decide without any process going on in parliament and go and say, I'm going to file an impeachment case, he'll be laughed out of court. He'll be told, impeachment, we don't deal with impeachment. Go to the parliament. That's where impeachment happens. On the other hand, if I was to go to parliament and say I'm going to file an election petition in parliament, they'll tell me you're crazy. Go to court, my friend. So actually, the forum, the home of impeachment is parliament.
Okay, sorry.
But the court, I think, should weigh in on whether procedure was followed.
Good point. Excellent point. So that has some legs.
Sorry, one moment.
Okay.
It's fascinating. Yes. This is the final ground.
Right.
Ground number 11. This was on
assistant bullying
of state and public officers. This is the one relating to which evidence that was presented? Was this the one on intimidation?
I should believe so.
The former head of KEMSA?
Yes, that's
this
the one.
Yes, this one
it's
has
about
also...
KEMSA
Yes, it was about KEMSA, yeah, Dr.
And the mosquito nets
Yes.
Yeah.
tender.
Global
And
Fund
the
tender.
infamous phone call to him to refund the bid bond
Andrew Muller, Shobika.
Shobika.
And you remember
And that,
that,
of course, has not been upheld by the senators.
Yes.
Okay.
And earlier, during the National Assembly sitting, you remember several members of parliament were saying how he's been treating them, disregarding them, calling them some names,
Right.
some very funny names that were mentioned by Kururia, Njoroge Kururia, I think the member of parliament for Gatundu North. So the Senate does not believe that it has been substantiated to an extent of impeaching the deputy president rather. But so far, five out of 11 grounds have been substantiated by the Senate and being used to remove the deputy president.
And he stands impeached, and I believe, let's listen to the speaker.
Senator Alan Chesang, proceed to the dispatch. Senator Karungo, proceed to the dispatch. Aye.
Yeah, it would seem the voting is, or is this where they actually do the verification?
It could be verifying the votes.
Yeah, of the entire process. You can also see there the senator from Nakuru. And is that nominated Senator Karen Nyamo as well?
Yeah, Senator of Nyandarua,
yes.
John Methu.
That's right, yes, absolutely. So, yeah, and Senator Thangwa too. So what happens now, Charles? The speaker makes the announcement, the final pronouncement. Like we've said, this is a quasi-judicial process. So allow my questions. I know they're simple.
Yes.
Is there a verdict, you know, a ruling, a judgment, you know? And do we now have, you know, a reasoned judgment like we see? Because we've seen a bit of a mix of what was a court process versus...
Yeah, when you have jury trials,
Yeah.
for example, in the United States of America or the United Kingdom, they don't give a judgment. They just give a verdict.
Yeah.
And if there's anything that is reasoned, it is the views of the judge or his directions to the jury before they give the final outcome. So you could say that the reasoning in this case that appears in the Hansard is the comments that were made by the senators before they voted. They're actually more like a jury because what jurors do is what the senators have done. It's only that their deliberations, and like for a jury which are private,
Closed door, yeah.
are public, and they've actually given their comments so that Kenyans can hear their reasoning for the decisions they've arrived at. So the only thing we'll have at the end of this process is a communication from the speaker about the removal and the necessary Gazette notice, formally communicating that position to the whole country. And then, of course, also communicating to the president, because there has to be formal communication to the president so that he can appoint or nominate a new deputy.
And that formal communication to the president is done in writing?
I would assume there would be a letter.
I suppose the outcome of the vote?
Yes.
Yeah, just trying to understand. Okay.
Yes, indeed. There would be, for sure, a letter to the president, and that letter would include the evidence of the outcome of the Senate resolution. Just to clarify...
Any chance all that will be happening at the same time?
The clerks, officials in the Senate are already drafting. If they had not finished drafting before, they only needed to add the ground that has succeeded. 5 of 11 grounds. Yeah. We noticed earlier today that the speaker walked out for 5 minutes and he came back maybe a bit longer, 10, 15 minutes, but he had a reasoned proposal.
And so did the majority leader.
He read it well.
Moving.
Yes.
He read it very well.
So they are prepared in advance.
Right.
And for sure, between now, 11:20 and midnight, those documents are likely to have been prepared, signed, and dispatched. There is an efficiency that is amazing for the public sector on this matter.
When the government wants to be efficient, it truly can. Abdikader?
So Parliament, first of all, has a very good public service. Most people don't understand that the actual work in Parliament gets done by the public service. Right. You realize it was not just the ruling of the Speaker, but the majority leader's application was also ready.
Yes.
The procedural motion That was also ready, which means by the time the 5 o'clock process was going, they had very serious meetings to decide what happens if this happens and the other on that item. But to follow up on the earlier question, yes, because I think it's a very important for our constitution. This is a very momentous day for our constitutional development. And it's good that with all the mistakes that we're starting with a DP instead of an actual sitting president, because the risks and the stakes are far much higher. So coming back to the discussion on, don't we need an adult in the room in the name of a court to try and look at the process to see? And that makes sense. The only thing is that our constitution takes a dim view of process defeating substance for purpose of a political constitutional history. If you remember, and Kenneth Matiba sued President Moi on an election petition, and it was defeated because he did not serve President Moi physically, personally.
Yes.
And he went to the Court of Appeal and he was told, no, you have to actually serve him. That was process defeating substance. You also remember, the lawyers will remember, for a long time, anybody who had a human rights violation against them could not go to open any case in the High Court. Why? Because Chief Justice, who was supposed to have done rules for the Bill of Rights, did not do the rules. So because the processes had not been done, you could not enforce your Bill of Rights. And so on, and you would be told you don't have standing. So, an NGO would go to court because somebody who has been disappeared, and they'll be told, are you the person? No, you have no standing. You have no locus, as the lawyers say. Because of all those processes, the Constitution says that you will not be denied rights, or substantive things will not be denied because of process. Now we have a situation where impeachment, the substance has been done. And to look at the process, we take 4 years and actually tell the person who was impeached, you go back to office. It's really a very dicey situation. So, sorry.
You speak about process, Wakili Gituku, a minute. You talk about process. One of the processes that was done, of course, I think preempting anyone going to court and saying the process was not followed because there was no public participation. So it was done. Yes. But then now, does the opinion of the court, public opinion, matter? What people say, does it really matter? Because if we listened to what people were saying during the whole process, something else came out that was neither we want to impeach him or want to keep him. There was something in the middle that said we want both of them to go. Do those things really matter? We talk about members of parliament and senators being a representative of the people, because when they speak there, they speak on behalf of the people who voted for them. Yes. But was the voice of the people ignored in this process?
I can come in on that point. I think what the courts have said about public participation, they have had so many cases on public participation that they've become quite clear. They've said it should not be a cosmetic exercise. They've talked about both quantity and quality. They've showed about demonstrating that you've not just allowed the people to speak, but taken into account their considerations. But they've also said that public participation is not veto power by the people. Those who vote are the representatives. So they should listen to the people. They should be able to give some kind of justification of why they've decided one way or the other. But assuming majority of the people said we want it to go one way, they don't have to agree, so long as they have a good reason for disagreeing.
All right. And just so you know, we will interrupt that now. Let's listen to what the speaker is saying.
Now, the result of the division is as follows. Charge number 1, ayes 54, nays 13, abstention 0. So the high ayes have it. Charge number 2, ayes 28, nays 39, abstention 0. So the nays have it. Charge number 3, ayes 19, nays 45, abstention 3. So the nays have it. Charge number 4, the ayes at 51, nays at 16, abstention at 0. The ayes have it. Charge number 5, ayes 49, nays 16, abstention 2. So the ayes have it. Charge number 6, ayes at 48, nays at 18, abstention 1. So the ayes have it. Charge number 7, the ayes 13, nays 53, abstention 1. So the nays have it. Charge number 8, ayes 27, nays 40, abstention 0. So the nays have it. Charge number 9, ayes 46, nays 20, abstention 1. So the ayes have it. Charge number 10, ayes 22, nays 45, abstention 0. The nays have it. Charge number 11, the ayes 18, nays at 47, abstention 2. So the nays have it. Now, honorable senators, the result of the division indicate that the Senate has upheld the following impeachment grounds. 1, gross violation of Articles 10(2)(a), B, and C, 27(4), 73(1)(a), and 2B, 75(1)(c), and 129(2) of the Constitution, and Article 147(1), as read together with Article 131(2)(c) and D of the Constitution. 4, gross violation, ground number 4, gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Ground number 5, gross violation of Articles 3(1) and 148(5)(a) of the Constitution and the fidelity to the oath of office and allegiance. Ground number 6, serious reasons to believe that His Excellency the Deputy President has committed crimes under Sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Ground number 9, gross misconduct that is incompatible with the high calling and dignified status of the office of the Deputy President and a member of the Cabinet and the National Security Council. His Excellency the Deputy President has publicly attacked and undermined work of the National Security Intelligence Service and its officers. Now, honorable senators, pursuant to Article 145(7) and 151(b) and 2 of the Constitution and Standing Order 78(8) of the Senate has resolved to remove from office by impeachment His Excellency Rigathe Gachagua, AGH, the Deputy President of the Republic of Kenya. Accordingly, His Excellency Rigathe Gachagua, AGH, ceases to hold office. I thank you. You may rise, honorable senators. Now, honorable senators, there being no business on the order paper, the Senate stands adjourned until Tuesday, the 22nd of October, 2024 at 2:30 p.m.
And there you have it, the declaration from the Speaker of the Senate, Amason Jeffer Kingi, on the business before the House today. He is now a former deputy president, that is Rigathi Gachagua, found guilty of 5 out of 11 counts that were before him. I decline any invitation to grant temporary orders of stay, stopping the president from nominating a new deputy president. In short, former DP Gachagua has 0 chances of getting favorable orders to stop nomination of his replacement. Charles, sounds like what you were saying about, this sort of race to the finish on either side because of the issue of, status quo. So, so explain to us the courts. They don't usually want to upset status quo?
I think there have been two standards that have been demonstrated by the courts. To be honest, it's not one standard.
Yeah.
And because people have a view about whether Deputy President Rigathi Gachagua was constitutionally and properly impeached or not, it's possible to take one of the two arguments. But the truth is that the jurisprudence of the courts right now is that you have cases like Mike Sonko, who once he was successfully impeached could not get a court order. And you also have cases like Kawira Mwangaza, who currently is enjoying a court order after she was successfully impeached, and Martin Wambora before. But Martin Wambora, you could say, was the first term of county government. This is the current term, Kawira Mwangaza. Yeah. So the truth is that the courts have two standards that have been applied, or one standard applied in two different ways. And it is not, I think, right to say there's 0 chance or there's 100% chance. The chance is somewhere in the middle. The fact is that in the case of the deputy president, and that's the extent to which I agree with Advocate Steve Ogola, because of the stakes of the office, unlike a governor where a single judge is dealing with a case, then the judges, psychologically, you could almost say, even jurisprudentially, they need to be more persuaded to stop the orders. But we do recall when the BBI process was going on just a few years back, nobody expected the BBI process to be stopped by the court, and it was.
Sorry, Charles, and I'd ask that you indulge me, all of you here on this special edition of The Gang with us. I want to take some reactions outside the Senate. The senators have filed out of the chamber and are now with Stephen Latour. Stephen, an interesting historical night. What are the senators saying after that momentous vote?
Well, indeed, Yvonne and the news gang, plus our guests there, the vote, the cast is out and or the die is cast. The vote by the senators was preceded by much what you will call a biblical evening. Because senators quoted from the book of Genesis to Ecclesiastes, to the book of Revelation, to the book of Proverbs, to the book of John, the book of Matthew, the book of Ephesians, the book of Philippians, all in preparations to take a vote that has now fired the deputy president, making him the former deputy president of the Republic of Kenya. And outside the Senate chambers, the senators are making their way out. The vehicles are now coming to pick the senators who've been here since 9 a.m. And we're just trying to see what some of the charges that you've been talking about there in terms of the number of charges that the Senate have been able to impeach the former deputy president with. That is 5 out of 11 charges that have been presented to the Senate. And that, of course, coming after a heated debate that took place from members of the Senate, those who supported the impeachment and those who really were against the impeachment, saying that the deputy president, now former, was supposed to have been given time to physically be here. And so that is exactly how the situation is. We have senators coming in. Just to look if I can get one reaction from some of those who voted either way to the motion. We see senators getting out. Okiya Omtata there, seeing senators just getting out, making their way to definitely going to take a rest. Remember, this exercise was supposed to end by midnight. But clearly, this has come early because the former deputy president couldn't take his 3 hours of defense, which means this process will have been combated or really squeezed into, this particular hour. And so that is the situation. We're just trying to see if we can see senators coming out of the chambers. There you have it, Senators. Karungo Adhangwa, the senator for Kiambu, who actually voted in opposition of the motion, and we have the senator for Kajiado, Senator Seki. We've seen you putting up a spirited fight against the impeachment motion that has now basically had the Senate make history of firing the deputy president. How do you describe this decision by the Senate?
Ningetaka kusema ya kwamba hii decision ambayo imechukuliwa na Senate haijaangalia mambo ambayo inahusiana na hali ambaye deputy president ameweza kuweka katika Senate ya Kenya, kwamba amegonjeka, hakuweza kupata nafasi ya kuwa kuulizwa maswali yale ambaye yameletwa na yule MP ambaye ameleta malalamisho haya. So tunataka kusema ya kwamba haiko fair, si sawa. So mimi nataka kusema kwamba deputy president hajapata nafasi ya kuwa cross examine, na hiyo inamaanisha ya kwamba hii jambo si sawa.
Asante. That is the senator for Kajiado, Seki, and senator for Nyandarua, Senator Methu. What do you take of the decision that the Senate has taken this evening?
Well, this is a political decision that has been made. We have been able to try and test the evidence. Everybody, even those who are at home, can be able to tell that we didn't meet the threshold that would be required to remove the person of the level of a deputy president. So I actually feel that this is not a motion that can be able to stand in a court of law that will be able to look at the facts and the evidence that has been provided in such a motion of that magnitude.
Thank you, Senator for Nyandarua. We will be able to get more senators also just giving their views. Senator Nyutu, tell us, what do you take of the decision that has been arrived at now that has made Rigathe Gachagua a former deputy president?
Thank you very much, Leto. And I think I don't want to agree with you that he's a former deputy president, because as you know, of course, we also have recourse in law because this is a process, this is something that was done in a very prejudicial way. You remember, because you know you are reporting, the deputy president is taken ill in the afternoon, and people did not care. They decided to continue with voting, and they did not even want to consider that his legal team decided to leave. Leto, we are Africans. We cannot condemn a man that is admitted in hospital. And I think it's a sad day for Kenya. And I think we will have our day in court. And I want to believe that the courts are going to overturn this most unfair trial process and the judgment passed by my colleagues, the senators.
Thank you so much, Senator Nyutu. They are giving us, but of course we have also members of the other house who are also present in the Senate. The Member of Parliament for Mbeere North. Tell us, what does the National Assembly take of this? And we see, are we going to see National Assembly have a sitting tomorrow, as was scheduled in the order paper?
Yes, tomorrow National Assembly will sit at 9:30 a.m. in the morning to deliberate on what the entire process of impeachment. We have seen Article 145 and Article 150 of the Constitution taking in place, where the members of the National Assembly, as well as the members of the Senate, have insisted the Constitution of Kenya is supreme. We, as the state officers who have been given different positions in trust by the people of Kenya, we must be committed to remain truthful. We must be committed to do what is right as far as our offices are concerned. Article 10 of our Constitution, we talked about the national values and the principles of governance, is key for any state officer, whether it's a member of parliament or the governor or a president or a deputy president. We have seen the constitutionality of our institutions, of our offices coming into play this tonight. And I think Senate has done a good work. The Speaker of the Senate has proved to be to espouse solomonic wisdom in making a very proper ruling so that we can have the kind of determination which they have come up with. So we expect the president to make immediate nomination of who to be the holder of the office of deputy president, so that we can be able to make a decision tomorrow morning, and Kenya can be able to move forward as one nation, one people, under one flag, united, and one indivisible nation, standing strong together under one constitution of the Republic of Kenya.
Thank you. Thank you.
And also, we are seriously, vouching for Professor Kindiki Kithure to hold, to be nominated as the Deputy President of the Republic of Kenya, so that we can move forward as one nation, one people, one flag.
Thank you. The two of you are in similar suits.
All right, the reactions continue from outside Parliament as that matter has been concluded. Let's talk about how this vote was conducted. Of course, what happened before the Deputy President was unwell in hospital, and we heard from advocates on both sides of this. In fact, those representing Rigathe Gachagua left the House saying they wouldn't be part of what is considered an illegality. And the matter that was before them was about whether the Senate can proceed without hearing the Deputy President. Of course, he made his submissions, at the National Assembly, but he was meant to be the star witness, give his testimony, and then be cross-examined. And one of the issues there was that the President or Deputy President needs to be heard based on Article 145. Abdikadir,
yes.
Will this likely be a ground for the litigation process going forward? I mean, this is likely to be challenged, no?
If at all there's any court process tomorrow, I'm sure this or the day after or next week, this will be a major issue. And there are those who think that if it was a strategy, that would be the linchpin for that strategy. And the argument, as you said, was that the Constitution says he ought to be given a hearing, and his advocates also ought to be heard. The argument being that if he was sick, he was not able to, and therefore he did not get the hearing. The argument from the other side was that this is a time-bound process, and that we cannot wait forever. Number two, that by virtue of the fact that the process starts at the National Assembly and ends at the Senate, that the National Assembly, the Deputy President, had given his piece, and that at the Senate, his lawyers had filed his affidavits, and that there was substantial information that he himself said, and that for the defense or for the National Assembly, they were actually the ones on the back foot, because they would have loved to cross-examine him. And there are those who also feel that part of, if it was a strategy, and this is a big if, part of it might have been cross-examination really is very, very difficult. Yeah. As a lawyer for the National Assembly, got to find out.
And the motion mover as well.
MP found out. Yeah. So that will be a major issue. Who decides at that point? Who decides is Parliament decides. And Parliament, if you remember, the Speaker, Parliament this time being the Senate, the Speaker gave a ruling and said, okay, I have, as far as is concerned, 10 days. The 10 days end on Saturday. I don't have the powers to extend the House to Saturday. You senators have that power. What I will do is ask you, can we extend to Saturday so that then we extend the hearing to Saturday? And that's why the procedural motion came, and I suspect he knew the answer would be no, and that how the answer was no, and therefore the answer is that we gave you a hearing. Unfortunately, you fell ill. We waited until 5 p.m., and we were unable to go beyond Saturday, and the Senate felt. So the Senate would have said, we have taken our decision based on our circumstances, and they would be comfortable with that, yes.
And just so everyone can follow, that particular matter falls under Article 145, that is removal of President and also Deputy President by impeachment. Article 145, 5 says the president or deputy president shall have the right to appear and be represented before the special committee during its investigations. 6 says if the special committee reports that the particulars of any allegation against the president have not been substantiated further, proceedings shall not be taken under this article. Part B is where this will be litigated quite a bit, perhaps, is that if any allegation against the deputy president have been substantiated, the Senate shall, after according the president or the deputy president an opportunity to be heard, vote on the impeachment charges. And so this is something for us to take note of, because I'm sure it's going to come up again and again going forward, should this process be, and this particular issue and matter be litigated. Sam.
Right, and I've seen a few sites online reporting that Rigathe Gachagua was the deputy president of the Republic of Kenya up until tonight.
Wikipedia, right?
Yeah, but I've also looked at the website of the President Rigathe. It still lists His Excellency Rigathe Gachagua as the deputy president. And the importance of this is because I'm taking a look at Article 149, and I think we had mentioned about it a little bit, but there's someone else who is saying that it requires Parliament to vet. This is an issue that has been spoken about.
That's another one, yeah.
But then probably it's a moment also, Charles, to even speak about it more deeply, because I would imagine there's a reason why the Constitution thought of, or the framers thought that you should give 14 days to the president once a vacancy occurs. And there's also a reason why, upon naming that person, Parliament, the National Assembly in this case, would have 60 days to vote. So help us walk that journey. And also, with this voting, is it just members of the National Assembly meeting, say, tomorrow to vote, or does it require involving the people?
Okay, so there are two schools of thought among lawyers on this issue. One school of thought is that the office of the deputy president is an elective office. And the fact that a deputy president has been removed by impeachment does not turn it into an appointive office. It just changes the manner of voting. Before, the voting was directly by the people in a general election, and after impeachment or after a vacancy arises, the voting is by the people's representatives in Parliament. So for that school of thought, the argument is that because it is election, you don't need to do the vetting that you do when you nominate state officers. The process that is followed is similar to the one you follow when you go for the polls. Some argue that for this reason, you need IEBC, the Independent Electoral and Boundaries Commission, to verify or validate that this person is qualified for election into office and to supervise the process. There are some who say of this school of thought that because the provision, Article 149, is all-inclusive, you don't need IEBC, but still it is a voting process, and therefore it is for the MPs to decide who to vote for. You will not need to do public participation the way you do for appointive offices or to follow that elaborate procedure. That's one school of thought. Mm-hmm. And those who support that school of thought say that the wording in the provision in Article 149 is quite different than the provisions that deal with appointment or nomination of cabinet secretaries and principal secretaries. And I was having that discussion with Senior Counsel Abdikadir just a few minutes ago. There is another school of thought that says that once the deputy president is removed from office, the new deputy president is coming in primarily through an appointment process. Yes, there is a vote by the National Assembly, but this then should follow a similar process as happens to other appointive state officials. That what counts is not whether the office is appointive or elective, but the process of the person coming in is primarily through selection, and that the National Assembly's job is to approve. However, the wording of Article 149 of the Constitution doesn't say approve, it says vote. So this is an issue that is live for constitutional debate. And I believe tomorrow or at any future occasion when the National Assembly meets, the Speaker of the National Assembly will make a ruling on what would be the procedure to be followed. And I believe the legal minds are already working hard at it. And whatever procedure they follow, the court has the last word on constitutionality. the last word on constitutionality of the process that has so far been undertaken, both in the National Assembly and in the Senate, to impeach and remove the deputy president, and also the final word on whatever other process goes on. So if it is found to be so fundamentally unsound or contrary to constitutional values and principles or the text of the Constitution, then it can be struck down. If the court agrees with the finding of the Speaker, because the Speaker has a right to interpret the Constitution for purposes of the House, then they will uphold the decision of the Speaker.
So why the 60 days? Why the 14 days?
So one of the things that the new constitutional architecture has done is try to avoid periods of extended vacancy in important state offices. And you will notice that even if the president is not there, and the deputy president as well, the Speaker takes office, and then 90 days later, you need to have elections. When there is a contestation against the election of a president, you need to resolve it within 14 days. First 7 days to file the motion and 14 days to resolve. So there's a generous spirit in the Constitution to give an upper cap, but there's no lower cap given. And so some will argue that it is really for discretion. But as I said, there are two schools of thought. One school of thought says that this process of nomination by the president and eventual voting by the representatives of the people, because they are representatives of the people in Parliament, and Article 118 of the Constitution says any action of Parliament, whether it is legislative or other process, requires public participation. There has to be an opportunity for vetting and also for the people to give their views. Personally, I am more on this side, aligned on this side, because I believe when you look at Article 118 and the other provisions of the Constitution, I think it would not make sense to me.
Which side is that, Charles?
The side that says that there should be some public participation, and that there should be some opportunity for the person to appear before, say, a parliamentary committee to be vetted before they are appointed. But I do also concede that there are those who are making a strong argument on the other side, like my colleague, Senior Counsel Rigathe.
And just to, it's 60 days also for the Speaker. If the Speaker is acting, the period is 60 days. So it's just the same period going for the deputy also. There is one section, actually, 149 and 140. Where I come from in terms of that opinion is that impeachment is a closed system. And public participation taken too far is a referendum. In fact, one of the issues that came up was if you had 20 million registered votes and you had 20,000.
Yeah, actually, Paul Mwite said it.
There
Out of
you go.
14 million registered voters, only about less than 300,000 gave their views.
Or 200,000.
200 odd.
So then the risk of that slippery slope is, at which point would you think it's legitimate to have been consulted? And where does consultation of the public end and representation of the people begin? So my view is the more we attach processes to impeachment, the more we make it a nullity. And that this particular device is a very specialized device. And there are many, many good things. But the fact that something is good does not mean it fits everywhere. So public participation is good. In my opinion, vetting a deputy president who has come through after impeachment is not one of those. When you have an impeachment, and look, think about the president, because the procedure is the same. Are we going to say the president who is coming in after impeachment will be publicly vetted?
Which means that's sort of almost another election? Perhaps of sorts. If you talk about the issue of public participation, again, in deciding, who would be the new president after an impeachment process.
So my view is that they are very good. Public participation is absolutely necessary in legislation making. It makes a lot of sense because you're making laws and